And then all of a sudden, on December 22nd, right before we're going to start trial, they stipulate. And then at trial, all of a sudden it's, oh yes, he wrote the cadaver. This is not either an attack or an argument. And it's not directed at defense counsel. It is directed at the defendant because defense counsel, when they give their opening statement about what the evidence is going to show in the case, they are speaking for the defendant as his lawyer. So that's our point. That's where we're coming from. I can tell the court is completely persuaded by my argument. No, I read the room wrong on that one. Okay. I wanted to at least have the opportunity to make the point, Your Honor. I appreciate it. Thank you.
Objection sustained. The point is a worthy argument, but you can't phrase it in terms of what counsel is saying or their words or images. Okay? Now.
We have another slide that is going to convey similar information, but it does not involve Mr. Chesnoff in the slide. In other words, that's what I'm understanding is the objection is that we are having Mr. Chesnoff quoted in opening.
That's what you're doing. That's what I am, sustaining that objection.
Thank you.
Next, defense opening. So this opening statement that I received is premised upon a different ruling on hearsay from the ruling I originally made. So let me go through that. Let me go through that issue. And so there is hearsay evidence that Kathy Durst is seen alive after the date of her disappearance. I excluded it. I wanted to think about it again. It's not an easy decision. I examine my decisions. I reconsider my decisions just to make sure that I'm right and that I'm being fair. So I may have overthought this one, but let me go through this. It appeared to me I might have overlooked a valid defense argument for admission of evidence regarding this material. And my son taught me that TLDR means too long, don't read. So I really have, this should be an opinion. I mean, it's too long. I'm not going to read it, but I'm going to get to the essence of it. The problem is that the legitimate basis for admitting this evidence is not Mr. Durst's defense. That's the problem. So let me go through, I'll give you a tentative, and I'll hear you out about it. It's hard for me to tell if the defense meant to make this argument. If so, they hid it in the brief and made two other arguments instead, so maybe not. At the hearing on the motion, the defense argued first that there's a constitutional right to present exculpatory evidence, citing several U.S. Supreme Court cases, none of which authorizes admission of unreliable hearsay. It's other sorts of evidence might be admitted. This is not like that. I rejected that argument. The defense also argued the evidence was not hearsay because it was offered to explain Detective Strzok's actions. But the reasons for Detective Strzok's actions are not relevant. And here's where I looked at great length at these. I looked carefully at these cases supplied by the defense, and I commend them for finding these cases, but I am going to follow People versus Lucero, 64 Cal App 4th, 1107 at 1109 and 1110. In that case, 64 Cal App 64 Cal App 4th, 1107. I could go into it, but too long, don't read. The non-hearsay purpose has to be relevant. Okay? Short form, in Lucero, the officer lifted the print of a shoe. He says, a witness told me that the perpetrator stepped here on this table, and that's why he took the print. That's why he tested that surface for print. So the statement, this witness, whoever he is, told me this, is hearsay. But it explains why the detective did it. It doesn't matter why the detective did it. It is hearsay. It has no tendency and reason to prove any disputed issue of fact in the action. So here, the non-hearsay purpose of explaining Detective Strzok's action is irrelevant and substantially more prejudicial than probative. It's unreliable evidence that would unfairly suggest that Mr. Durst did not actually kill Kathy Durst. The defense cited People v. Samuels, 36 Cal 4th 96. On this issue about a detective testifying about why he did something, the defendant failed to make a specific and timely objection on hearsay grounds. She failed to preserve this claim for review. That's the holding. When Justice Janice Rogers Brown, now of the D.C. Circuit, wrote this opinion, she wrote, the testimony was used to explain Detective Daly's reasons for obtaining search warrants. The trial court did not err, which is dictum. When you look at Lucero describes two kinds of cases, People v. King, 140 Calap 2nd, page 4 and 5, 140 Calap 2nd 1, and People v. Reyes, 62 Calap 3rd 53. What the officer believed was an issue in People v. King, because the determination was, is there probable cause or not? In People v. Reyes, the court explains that King doesn't apply if the legality of arrest is not an issue, if reasonableness is not an issue. So I think it's unfortunate that, and I don't really agree that that would have been relevant, but it's dictum. So I think I can respectfully disagree with the justice on that point, because it misses the distinction between King and Reyes. So in general, what a detective happens to think is not relevant. If that were the law, the defendant's rap sheet would be relevant. The hearsay rule would not apply to detectives. But because it's dictum, the words are not authority for the proposition that a detective's motivations are relevant as a matter of law. If it is relevant here, somehow I'd exclude it under 352 for reasons I explained. People v. Zavala is another case that people cite. It's a robbery case where the robbers were incriminated by records of their calls to each other. The Attorney General, I'm quoting Zavala now, the Attorney General contends the detective's testimony regarding the call records was not hearsay, but rather the call records were non-assertive conduct, admissible to prove the cell phone was an instrumentality in a criminal enterprise. Right. I mean, this is parenthetically, this is correct. The Attorney General is correct. The court wanted to make a point about the importance of the trial judge's discretion in having as long as a decision on evidence isn't arbitrary, they're going to uphold it. And so they said, we need not consider the contention that it's not hearsay. The trial court admitted the testimony over the hearsay objection for the limited purpose of explaining Maxwell's investigative steps. The court's decision to allow Maxwell's testimony while limiting the purpose of its use for the jury was not arbitrary because the testimony explained the detective's steps in his investigation. There has been no clear showing of abuse of discretion. So no clear showing of an abuse of discretion is not the resounding authority that such things are relevant as a matter of law. So I'm not going to follow that case. I will follow Lucero. So the point is the non-hearsay, let's say there's a hearsay purpose that Kathy Durst is seen alive after her disappearance. So that's proving the truth of the matter asserted, not allowed. These witnesses are not here, and the U.S. constitutional cases don't allow it. But what is relevant? And I don't want to exclude a defense, all right? I want to be very careful that a legitimate defense is presented. So I look back at the 1101B case law that we had discussed about what it's a framework for analyzing relevance. The reasons for Detective Strzok's actions are not an ultimate fact because they're not an element, they're not a defense, nor are they intermediate facts because Detective Strzok's actions don't tend to prove the additional intermediate fact of whether Mr. Durst killed Kathy, because that's intermediate. That's not the ultimate fact is, does he fear prosecution? Because Susan Berman was a witness to a crime. So it doesn't tend to prove that Mr. Durst believed that Susan Berman was a witness to a crime. Detective Strzok's actions or his reason for that don't prove that. But here's where I thought the defense could have a valid argument, even though it wasn't clearly stated. What the defense team seems to state on page 6 is, quote, "This information is also exculpatory and shows that Mr. Durst was not charged." So because this evidence seems to be the reason he was not charged, that could tend to support an expectation that he would not be prosecuted, and thus Susan Berman was not a witness. The problem with this for Mr. Durst is there's a lot of evidence which contradicts that, but that doesn't make it inadmissible. It doesn't make it inadmissible. Ultimately, the jury decides which admissible evidence to believe. The second problem is it opens the door not only to refutation, including good faith cross-examination, that this whole story was fabricated, that it proves consciousness of guilt, it corroborates the motive to kill Susan Berman. So what does matter is whether, in fact, Mr. Durst makes this claim. The ruling I made precludes him from testifying about this, right? My ruling stops him because it's hearsay. So it appears to be a tactical choice. So the defense actually has the best of both worlds. They don't have to present what might prove to be an untenable defense, and they can argue they're denied the right to present it. So to me, I thought these developments were an important part of the people's case. It's the way I always heard the story from the evidence. It showed because it showed efforts to conceal evidence. The problem is that proving 40 years later that it's fabricated is probably impossible. So we don't know if it's true or not. It appears to be untrue. So the people did, I think, legitimately object. This is hearsay and very unreliable hearsay, which not should be allowed to unfairly raise a reasonable doubt that Kathy Durst was murdered. So I excluded it. But there's this non-hearsay purpose, which depends on Mr. Durst claiming and probably testifying that he did not fear prosecution. So May 3rd, I gave the parties a heads up because this would change your statements, it might change your tactics, and I said, I am reconsidering it, I want you to argue this. So I was inclined to allow the non-hearsay claim, but then I did receive an opening statement from the defense that assumes I'm going to let this in, and instead this reaffirms the opposite. So slides 51 through 53 points to the same unreliable hearsay as proof of the matter asserted. And that's a problem. The evidence is not reliable. The people presented evidence at a 1390 hearing, concurrent with a preliminary hearing, proving the killing by a preponderance, and it's difficult, if not impossible, to refute this evidence except by inference. And because of the passage of time, it's hard to prove it definitively. So a jury could easily be misled. So I want to be clear. Mr. Durst would be allowed to testify about this, Okay, not for its truth, subject to a limiting instruction and cross-examination. So knowing this, that it's admissible, and conceding he did in fact fear prosecution is now a clear tactical choice. Right, Mr. Chesnoff?
Agreed.
He knew that Jeannie Pirro had resumed the investigation, and that's why he left. And that's in slides 36 through 39. So, no, I'm sorry, that's in slides, not correct. It's in slides in the 51, 50 through 53. Slides 51 through 53 describe that. So, slides 36 through 39 are documents on this subject that I have said are not admissible. And if you're exercising that tactical choice, you must remove those documents. I will sustain the objection. You're nodding, Mr. Chesnoff. Thank you. Now, there are other documents.
Sorry, the documents that you want us to remove.
These are documents pertaining to like a drawing of a perpetrator, letters, and they're documentary evidence that points to this question of the.
They're all the story told by the doorman and the manager, and we're saying that we're able to talk about it in the context of him not being afraid of prosecution, but we cannot use the pictures in the context that has been presented to you because, in your opinion, Your Honor, they're being offered for the truth.
They're offered for the truth of the matter. Now, if he doesn't fear prosecution, your slides 51 through 53 say he did fear prosecution.
But that's 10 years later, but 20 years later.
I see. I got it. So at the time, he did not fear prosecution because.
I mean, at the time, Your Honor, he knew that the doorman had said it. He knew that the manager had seen her walking away. He knew, even though it's not admissible for purposes of presentation to a jury, that the fellow who said that he had seen her had actually been subject to a polygraph.
So here's the thing. So yes, he didn't fear prosecution then, but that's not relevant. What's relevant is that at the time of the killing of Susan Berman, he believed that she was a witness. And what's relevant to that is because he was going to be prosecuted for a crime.
Except at the time that we're talking about is allegedly the time that Susan would have participated with him. But if he knew he wasn't going to be prosecuted, there would have been no need for Susan to have participated with him in, as the state wants to believe, calling the school. Because Mr. Durst's mind was that, in fact, she was seen in the city and he wouldn't be prosecuted.
So he did not feel she would be prosecuted at that time. You're offering that as a theory that she must not be a witness because having not.
Your Honor, when would the people be able to briefly be heard on that?
Oh, after I
And we
explore
can
this.
assist the court.
Yeah, no, I'm exploring this here. So I don't want to forget another point. So the question is now, okay, I got it. I hadn't thought about that one, so I will think about that. Now, there are other documents in the opening statement. I believe I recognize them, but I want to ask you, are those covered by stipulations that you have, or have I otherwise ruled those other documents admissible?
It depends on which documents you're talking about. Yes. Some of the documents were admitted during Struck's testimony of his conditional examination.
There are some documents here which pertain to Kathy Durst's performance in medical school and any issues or obstacles she might have been dealing with at that time. And I remember the cross-examination about it. I don't recall if there is an answer as to whether these documents are admissible. And here's the problem.
Business records,
Look,
business
please, I
records
can-
of the school, or the medical school.
Okay.
They were all in the business records of the medical school.
Dick, let me assist on this, Your Honor. We have a stipulation.
That's all right, I appreciate you trying to assist me, but.
Dick, I'm not assisting, I'm answering the court's question.
No, if he's going to concede that you
There
can
was,
show him.
there was an agreement, you probably don't want to fight me on this, Dick. There was an agreement by both sides that the records from which were marked, that those records from the school and from the rotations, that there was a stipulation they could be utilized by both sides. Because we don't know, we haven't seen what those documents are they're referring to. As long as those are the same documents that there was a stipulation on, those are properly in the opening statement.
Are there others?
Well, yes, there are two classes. There are documents that are from the medical school. Then there are documents that are part of the police reports. So those are two separate classifications of documents.
So those police reports, not the ones where Detective Struck is interviewing people, because I already told you you can't show those. Is this something else?
Well, you mean today you told us that?
Yes.
That's what I thought you were saying we would be
Yes.
able to use.
Well, I mean, subject to this, we're going to have a little argument about it, because Mr. Chesnoff has given yet another theory that I want to think through. But go ahead.
Okay, so there's those other documents that are actually police reports from the police records.
Of Detective Struck, or the New
Detective
York?
Struck and his partners, all the officers that were working on it together, and it's in Detective Struck's conditional examination. All those documents were referred to and shown during his conditional examination.
The court can already, Your Honor, if the court recalls, we already have a stipulation, an agreed upon agreement on what it comes in with Detective Struck. Those documents, which the defense was allowed to bring to the conditional examination, were always double hearsay, sometimes triple hearsay. They were not part of the agreement which counsel signed. We already have an agreement as to what is going to be played in Detective Struck's testimony. It's already been signed, accepted by the court. Those are not in there. Apparently, and again, we haven't seen it, what the defense has done is they have decided that they want to bring in evidence, police reports, information that Detective Struck testified to, which is inadmissible and which is not part of the agreed upon stipulation as to what the jury will be able to hear.
Let's focus though. We're not now talking about the sightings. We're talking instead about investigation of her problems.
Your Honor,
Right?
we are talking about sightings, I'm sure.
Yeah, we're talking about the site.
Well, I'm excluding that unless Mr. Chesnoff persuades me there's another theory.
Well, that's what I wanted to speak to, and that's why I'm saying there's the difference between the medical school records and the police records. The police records that we've got in our opening were all referred to during Struck's examination. Yes, we have a stipulation in Struck's examination. The stipulation was done before the court told us that you were rethinking the situation. That's why I put it back in.
Right, now you're probably going to take it out unless Mr. Chesnoff convinces me that it's relevant.
I'm depending on Mr. Chesnoff to do that, and if he doesn't, I'll try myself too.
Okay.
But that. So we know we're talking about the same items. I think that your citation to the numbers are off, but I mean the slide numbers, because I've got it here in front of me and I'm looking at those slides.
All right. So, but it seemed there were quite a few documents, and some of them didn't even pertain to this issue, and I wasn't familiar with the documents, and I didn't know if they're admissible or not.
Your Honor, with respect to, if we can briefly be heard, I think it's important on this issue.
Yeah, of course you can be heard.
Because this is, it's a double issue. The first issue, and the easy one, people's position, is that nothing about the elevator operators can come in, or building employees, et cetera, can come in during opening statement. Because unless and until there's evidence presented that meets the court's threshold, which as I explained in the emails that were sent to the court and counsel, we laid out our position because obviously we didn't have time in the court had authorized this procedure.
This unless and until thing is one-sided because I'm allowing counsel to present what they believe the evidence will show. And they must be mindful of evidence that I have excluded or certainly would exclude.
Right, Your Honor, so if I can continue, and I think this is very important. So there's two separate issues. What are they going to be able to get in eventually versus what can they bring up in opening statements? And this is what the problem is. The court came up with, and I understand, and the court said the court might have thought this one just too much, but what happened is the court came up with an independent area of relevance for the non-hearsay use. Now the problem was, and the court, there's no way the court can know this, that is not just completely inconsistent with every statement the defendant's made up until the opening statement. It's not just inconsistent, it is the direct opposite. And I want to play as a part of our argument, Your Honor. This is a key point. It's about a minute long, and this is Mr. Durst speaking. This is a slide that was already played in our original opening. But this is Mr. Durst talking about why he went to Galveston. This is the identical issue.
Yeah, I mean, I think I already know this, but...
Well, before we play that, let me make this really clear.
Yeah.
Judge, he went to Galveston 20 years, 18 years after Kathy Durst disappeared. His motivation for going to Galveston 20 years after she disappeared is different from his motivation for not running. When the detectives found two witnesses that saw Kathy Durst in Manhattan on February the 1st.
Right, and so my question, I want to focus you is it relevant that he didn't run then? Does that go to an element of the charge?
No, Your Honor.
Yes.
Considering that Mr. Lewin has repeatedly talked about 3 homicides, it's 100% relevant as to whether or not Kathy Durst is a homicide that Mr. Durst is responsible for.
Oh, okay, but no, it doesn't. That's you're just doing an end run around the whole hearsay analysis. Yes, it's relevant. Of course, it's relevant, but it's hearsay.
But Your Honor, you asked the question, how is it relevant? It's relevant because he keeps saying that Bob Durst killed Kathy Durst.
Yeah, okay. That theory is this evidence. You may refute that with other evidence or cross-examination. That evidence is not admissible to prove that point.
Because that would be a hearsay use of the evidence. That's really the evidence for the truth of the matter asserted. Your Honor, may we please?
It's Bob Durst's state of mind. His state of mind at different times.
When?
Exactly. State of mind in 1982, February 1st, et sequence. After that, his state of mind was the police were doing a great job. They developed 2 witnesses who'd seen Kathy Durst in Manhattan on February the 1st. That means that she did get on the train and she did go to Manhattan. And she wasn't killed in South Salem as the prosecution says. Now, it goes to his state of mind in that Mr. Lewin has said that it's inconsistent that he claimed to run to Galveston because he was afraid of prosecution. That's 18 years later when Janine Pirro and all of her troops and her television crews that followed her around everywhere tried to claim that they were not on Bob Durst's trail, and he was told that she could get a ham sandwich indicted by a grand jury. And so he panicked and ran.
Okay.
That's a different state of mind in 2000 than it was in 1980.
As far as I'm concerned, 2000 is the relevant period of time. But go ahead, yes.
One other point, Your Honor. If he understood from the police that she was seen in New York after he put her on the train, and he got that information, it undercuts the speculative theory, and it's been pure speculation, that Susan Berman is directed by Bob to call the school, because if he thought she was seen in the city, he would not have any reason to have had her participate, and therefore she's not a witness, and therefore that's very relevant to the question of whether or not he murdered a witness.
Wait, he doesn't have to believe that she was seen. He has to believe there's a witness who would say she was seen, because this is not about the truth or falsity of the question. Again, 1982 doesn't matter. It's not a state of mind in 1982.
Well, what
It
about-
does, is she a witness at the time she is killed? That is the question. Does he reasonably perceive that she is a witness? It's not just that she is a witness, but he knows she's a witness, and he kills her because she's a witness at that time. If he doesn't believe at that time that she is a witness because he's not going to be prosecuted,
But Your
fine.
Honor, doesn't it undercut the theory that he would ask Susan to make the call? That they are, I mean, everything is so attenuated, and then the one thing that Mr. Durst can rely on, which is the police, we're being asked to ignore that he can rely on the police.
Okay, let's see. What do you think?
Because, I mean, for once, did somebody presume that he didn't do this?
Your Honor, at some point, we've said almost nothing during this hearing.
You're going to show me a movie?
Well, I would like to be able to make, I'd like to be able to make our point, Your Honor. May I'm trying to be as,
You're being good, Mr. Lewin.
I am, it's hard,
appreciate it.
it's hard for me, will the court just let me know, will I get a chance to respond to this?
No, this is entirely one-sided.
That's what I'm worried about. That's what I'm
One-sided,
worried about.
not the DA's office. I'm not going to hear from you guys. Of course I'm going to hear from you.
Okay.
You want to show me the film and then?
Yes, Your Honor, but I want to say something
Yeah.
immediately before that.
Yeah.
This issue came up because, and I think we're getting a little bit off track here. There's no question or issue about any flight, about any issue of Mr. Durst in 1982. The issue comes up, and what's relevant is that the people have made the point that Bob Durst fled to Galveston when he found out about the reinvestigation into Kathy's death. That is the motive for him going to Galveston. That is the motive for him them killing Susan 6 weeks later. And that's the motive, in part, for him killing Morris Black. The court had said, oh, wait a minute. If Mr. Durst, in fact, did not believe that he was going to be prosecuted, was not afraid of prosecution, then the people's theory about why he fled to Galveston would be inaccurate, and he would have a right to be able to present evidence to say, wait a minute, I was aware that there was evidence, and then it would have to be figured out how under 352, how under with limiting instructions, how you could get in that evidence. Different issue. Then he would be able to meet potentially the standard. Here's the problem. The problem is that every single statement that he has made up to this point, even including the defense opening in this case, says exactly the opposite. I want to play, very briefly, Your Honor, this is going to be Mr. Durst from the Jinx. Hold on. Ethan, I have to do it up here. No, I have to watch. Dude, I can't see it. It's not showing that. No, dude, it's here. That's fine. I can't press it. I can't find it. Dude, so it's, you have it on there.
Can you leave that to Mr. Milius, and I'd ask you to address a different question? Or are you going to really show that?
Yes, Your Honor. So
Here's a different question. Mr. Chesnoff's argument is a different argument. Mr. Chesnoff says, Bob Durst would testify and say, he did not think Kathy Durst was dead. If he had thought Kathy Durst was not dead, because he did not think Kathy Durst was not dead, because he thought she was alive, he would not have asked Susan Berman to call the medical school. So it's not credible based on the other evidence, but that's for the jury to decide, right? So is it relevant if he testifies to say he did not think that she was dead? Because he did not think she was dead, of course he would not ask Susan Berman to call the hospital. Why on earth would he do that? She was alive.
So Your Honor, so let's look, first of all, that's an argument that has never come up by anybody.
Yeah, but he...
Until this very moment.
That's okay.
Okay, but let's leave that aside for a moment. Let's assume that that is correct. The foundation for that can only come from Mr. Durst and would have to come from his testimony. Unless and until he testifies to that, the danger under 352 of the court, because here's what the court would have to do. If the defense is going to put up evidence or argue or address an opening statement that there was allegedly somebody who saw Kathy Durst after the people are saying she was dead. So here's the problem. The court would then literally have to stop the opening statement and instruct the jury, now listen, you are not allowed to consider that evidence that Kathy was allegedly seen, if believed. You are not allowed to consider that evidence for the fact that she was actually seen and for the truth of the matter asserted that she would be alive. Under 352, without question, that puts everybody in a position, Your Honor, it is analogous to an opening statement where you have an inadmissible confession of a defendant for the people to get up and say, listen, I'm going to play this confession, but you're not to look at this confession for the truth of the matter that you confessed. You're to look at it so it demonstrates demeanor in the interview. So let me briefly, Your Honor, show this goes to the argument that the court made. So the court made this argument regarding why he fled to Galveston. And here it is, Your Honor.
Yeah, okay.
And the whole idea of being charged with something, having people invest, and not so much investigate, but that people are going to find me guilty. I mean, I've been guilty for years in the newspapers, et cetera, et cetera. Now they're really going to find me guilty. And if they don't find me guilty, I'm going to be in jail, you know, on whatever, before the trial, et cetera, et cetera, et cetera. So what I did was I decided I got to go into hiding. And I had an apartment in Dallas. I'd been to Galveston, Texas a bunch of times. It seemed like about as good a place to hide as there was in the world.
So that addresses, and I just want to be clear, there are numerous statements going back to 2001. There's testimony by Mr. Durst in his trial under oath that he fled to Galveston because he was concerned about the charges.
Okay, they conceded that. I think that
okay.
They conceded that. That's not the argument anymore.
Okay, so now we have a new argument. So now let me address the new argument.
Yeah.
So the problem with the new argument, Your Honor, is that in the end, unless and until Mr. Durst testifies, they don't have an argument. So under 352, Your Honor, you are certainly, and we would think the responsible decision would be to say to the defense, listen, I'm not ruling out you being able to get into this area if, in fact, you demonstrate its relevance. That relevance is going to have to be demonstrated, and in this case, Mr. Durst he's got to testify. They've already said he's testifying, and the information they've given about what happened with Susan Berman, only he can testify to. So if he gets up on the stand and he makes a sufficient offer of proof, whether the court believes it or not, at that point in time, it could be relevant, but only, Your Honor, not anything about Mike's Detective Struck interviewed a witness, the witness said X, Y, Z. What it would simply be is, Mr. Durst would be able to testify, I believed that there were individuals in my building who had seen Kathy Durst on Sunday night, Monday morning. Now, the next issue which becomes extremely important is related to this. For 5 years, I offered to the defense to stipulate to otherwise admissible testimony of unavailable witnesses. I brought this up in court, Your Honor, no less than 10 times. I sent more than 20 emails. The court is well aware of this. I extended the deadline 2 years. And then finally in November of 2019, I said, you know what? I've heard nothing from you. You've not asked for it. That is gone. And the reason it's gone is because, as the defense knows and they have the discovery, the witness that they're referring to, Eddie Lopez, has been completely, and if I may finish, has been completely and absolutely impeached. The witnesses that would impeach him, though, unfortunately, once that issue was gone, when the defense said, you know what, nope, we're not asking for that, those witnesses, the two of them, last time we looked, they were in the Dominican Republic in Puerto Rico. We don't even know where they are. And the idea that at this late juncture, when they had 5 years, Your Honor, to take me up on what I offered.
But again, I mean, that's conceded. It's a tactical choice not to go that route. What they're proposing now is instead a non-hearsay purpose of Mr. Durst recounting this, and obviously he can't authenticate these documents, or maybe he could, and I don't see how he could. And he could say, I knew there was this evidence out there, and no, that's not true. He said, I believed that evidence at that time. I knew, so I did not. I did not do the thing. I did not do the thing that. Well, wait a second here. So, wait a second. The pardon?
It's just state of mind.
Right. No, I got that. So. Does that, okay, does that,
I think I can assist the court, Your Honor.
yeah,
In the end, what Mr. Durst,
Top liver.
and where we have no objection, if the defense, in their opening, wants to say, Bob Durst is going to testify, and he is going to testify that he believed that there were witnesses who had seen Kathy Durst after she had disappeared, allegedly been killed, and because of that, he did not fear prosecution, or he did not need to have Susan Berman call pretending to be Kathy Durst. As absurd as that is, if they want to present it in that way, that's what they would be able to do. What they can't do is they can't involve Detective Struck in their opening. They can't show documents. They can't say a building operator said X. They can merely say, you're going to hear from our client, he's going to testify that he was not afraid of pick your topic because he believed there were witnesses who would support the fact that Kathy Durst was not killed, that she made it back to Manhattan on Sunday night, Monday morning.
Are you sure? Because then he'll say, well, why did you believe that, Mr. Durst? He says, well, look at these documents.
Well, Your Honor, the problem that you have, and this is what the court is going the back route to find, the problem is that Mr. Durst's belief under 352 for this issue is substantially outweighed by the prejudice involved, and the court understands this. You cannot have a situation where you have evidence being produced that allegedly the murder victim was seen after she's dead, and then tell the jury, well, disregard this evidence that she was seen. You can't use it for the actual truth of the matter asserted. It goes to Mr. Durst's state of mind. And the problem is that even if you want to do mental gymnastics and find that there is tangential relevance or a potential theory that could be come up with as to how that might be relevant, under 352, the prejudice involved, and especially when this is an issue, Your Honor, that the defense had 5 years to litigate.
All right.
Your Honor,
we're in essence, Your Honor, it's not just that we're being ambushed right before trial. We're literally, they've come up with a theory, Mr. Chesnoff today. That is a theory that they have never expressed. It's never been written. It's never been uttered in a courtroom. We're 24 hours from giving an opening statement. They've had this case for 6 years.
First of all, Your Honor, we thought it went in under a different theory. The court ruled against us and excused us for trying to help Mr. Durst by thinking of things that qualify. Secondly, Your Honor, It's not like he goes to jail if he doesn't win this. Mr. Durst is the one who they have the burden to prove, and we have to defend. And his state of mind, Your Honor, is very relevant because everything that they're doing in this case with respect to Kathy Durst is completely circumstantial, and it is completely reasonable, since the evidence will show that he was in communication with the police, he was talking to the police, he also knew the people in his building. The idea that Mr. Durst had a state of mind that people had seen her in New York, as he reported. Everything that Mr. Lewin talks about presumes that Mr. Durst did not tell the truth when he said he put her on the train. This is his state of mind, Your Honor, and that needs to be told to this jury. What an injustice to be able to prosecute him for a murder that he's never been convicted of, prosecute him for another murder that he's not been convicted of. At some point, Your Honor, there's got to be justice suggested by both sides, and every time we come to something that actually is exculpatory, Mr. Lewin says that it's going to do a prejudicial disservice to the state of California.
Okay, don't get too carried away. I mean, here's evidence that has the earmarks of
Did not say one
factual.
thing.
So I mean, for a person to use this to 40 years later is inferentially, I think this is so. Okay, so I mean, you have a right to present admissible evidence that may raise a reasonable doubt. That's admissible evidence.
Your Honor, in our position,
Yes, Mr. Ray.
Regardless of whether Mr. Durst testified to it, let's take the position that the people are saying that he's not going to testify to it. The fact of the matter is, if the evidence comes in that these statements were made, not for the truth of the matter necessarily, but the fact that the statements were made, there's no doubt they were made, that in and of itself is the people who work in his building. That is evidence himself from which the jury could conclude that he knew that these people had said this, that he knew that they were saying these things, and that would put him in a position where it would be absurd for him to tell Susan Berman to make a call on behalf of somebody who these people were saying they had seen.
Of course.
Even if he doesn't testify to it going in, although I suspect that he will. That is direct evidence of his potential knowledge of information which would make telling Susan Berman to make that phone call to be ridiculous.
I see. And I only am hearing this today now. I mean, this isn't even the idea that I suggested might be just negate an element. This is a new theory this afternoon.
Respectfully,
In other words, like if it fits, we'll do it. And I'm sorry, I just thought that it might have been your theory because that's what your brief said.
Respectfully, Your Honor, one of the things is, even if this is a brand new theory, I don't think it's really all that brand new, but even if it were, we as defense counsel have a right and an ability to bring in theories that we think of anytime, even in the middle of trial. And for the people to say that he was talking to us about something else, I think is absurd. The issue is it in fact relevant evidence which could bear on the jury's determination of the defendant's state of mind? And there is absolutely no doubt that it could. And to exclude that evidence then excludes him from the admission of evidence which the court will want to accept it for the truth, but of evidence which clearly he would have known under these circumstances and clearly would have made his statement to Susan Berman as to supposedly make a phone call irrational.
the problem is Susan Berman made the phone call on February 1st. The problem is this information was not reported. It first appeared in the New York Post on, I believe by memory, February 8th or February 9th.
Yeah, but he knew about it before the Post.
Let's back up. We don't have, right now, Your Honor, we have no foundation that is correct. What we have is, well, again, as the defense said, Boston Commons, I think is the show. There was a Boston Law, Boston Legal, they used to have, they would call it Plan B. They're in the middle of court. They filed a motion, completely different purpose.
I guess Mr. Lewin.
And now, let me finish. Mr. Ray just made the point. Hey, Judge, listen. If we think of something, some crazy theory in the middle of trial, whether it's relevant, whether it's what we said before, hey, we should be able to throw it up there and see what sticks. Here's where we're at, Your Honor, with the point that I'm making. They are now saying, well, wait a minute. It's not relevant because Bob Durst would have known that the elevator operators had seen Kathy before Susan Berman made the call. But here's the problem. By Mr. Durst's own statements regarding his timeline, he doesn't even realize that Susan Berman, that Kathy, is missing until February 4th. He thinks that she is just allegedly doing rotations at the hospital. So let's understand what they're saying.
Wait a second, that means you can cross-examine him on that and he'll be proved wrong.
Well, Your Honor, there's a difference between...
Well, that means that she's alive.
Trust me. Cross-examination is going to get your popcorn and your candy and a lounge chair because it's going to be a while.
Sure.
But here's the problem. Whether I can impeach Mr. Durst during cross-examination is a different issue than whether, in fact, we should be interjecting complete hearsay disguised for some non-hearsay purpose when they keep throwing out, Your Honor, different non-hearsay purposes. Now, as the court said, in their opening statement, they gave themselves away. They are not trying to use this for a non-hearsay purpose, Your Honor. They are trying to use this to try and influence this jury that, in fact, Kathy Durst was seen. That's an observation the court made in looking at their opening statement. So, again, Your Honor, for all the reasons that we have said, and the most important thing that needs to be done right now, Your Honor, is simply the defense should not be allowed to discuss this issue in opening. That gives the court the entire time until Mr. Durst testifies to assess whether or not the court believes it's relevant, whether or not the court believes it's 352, whether or not the theory and the information and evidence that they have produced is consistent with it, then the court can make a ruling.
Your Honor, can I just...
Time out, wait a minute, hold on.
Mr. Bailey,
Hold on, please, Your Honor. Well, let's be
Speak to Aaron's loud, something like that.
He's got his hands up. Oh.
Look, this isn't some late arrived theory. We've known from the beginning that Eddie Lopez saw Kathy Durst on February the 1st. They say they offered to stipulate to that. No, they offered to stipulate to anything that was otherwise admissible. It was clearly a hearsay statement. So we couldn't stipulate to that. So, but that's a lie.
Counsel,
But that's not a lie.
It's a lie.
Okay, go.
Look, can you stop me from floating, saying that
Down.
Your Honor, the
Everybody be
Go to your
seated.
corner. Go to your
Be
corner.
seated. No, be seated. Sit down. Sit
We
down.
offer-
No speaking. No speaking. Sit down. Right.
No, you may not continue. We are going to be silent now. Mr. DeGuerin, you may speak first.
Thank you. The offer to stipulate was to otherwise admissible testimony. Of course, we couldn't stipulate because it wasn't otherwise admissible. Mr. Durst kept abreast of what the police investigation was. He was very relieved to find that Eddie Lopez, who he knew, and that Roberto Vittori had seen Kathy Durst on February 1st. He reported her missing several days later when she didn't show up. And that started the investigation. The investigation by Struck developed those two witnesses, among others, but those two primary witnesses. Mr. Lewin says that Eddie Lopez was impeached. Here's about that. Eddie Lopez went and underwent hypnosis. He underwent that other thing that starts with a P, I'm not supposed to mention here. And he drew or helped draw a picture of the man that he took up to Kathy's apartment 30 minutes after she went up to the apartment. All of that was very heavily investigated by the police, and that encouraged Mr. Durst to know that they were doing a good job, and hopefully something would come of it. And he was not even considered a suspect at that time. It was later in the investigation that they considered him suspect. Now, that having been said, that's Mr. Durst's state of mind in 1982. That's why he didn't run then. And that shows his state of mind. Mr. Lewin seems to think, and has said to you several times, that unless and until Mr. Durst so testified, we can't mention that. But that's not the purpose of an opening statement. An opening statement is what we reasonably believe the evidence will show. And so certainly, just as I said in opening statement, that Mr. Durst will testify and he will say that he found Susan Berman's body and wrote the anonymous note, hoping that the police would find her. Just as I can say that in opening statement, even though Mr. Durst hasn't testified yet, I can say what Mr. Durst believed at the time that Kathy disappeared. And that I can say in opening statement. We don't have to wait until and unless he so testifies. That's not the test for an opening statement. So, plain and simple, Mr. Durst knew about the ongoing investigation. He even posted a $100,000 reward for information leading to her, and he assisted for a while, for several months, in the investigation until started turning more accusatory, and then his lawyers told him to stop. Those are the facts. We've known those facts from the very outset. We've known them in Galveston, when we were in Galveston. So this is not some late theory. The legal ramifications of it are complex and complicated, and we're taking guidance from Your Honor because you originally told us that that wouldn't come in evidence, that the Eddie Lopez hearsay wouldn't come in evidence. We've accepted that, but then when we got your email that you had rethought it, we saw that you were correct about that, and that this does explain Mr. Durst's state of mind.
Thank you. Mr. Lewin.
Your Honor, so
And please note the time. It's important that we let our staff go at the right time.
That's an hour fast.
I'm going to be as quick as I can.
Is that our, is it?
But it's still 4:30.
It's 4:30.
So, Your Honor, what the defense has now just argued is that in essence, Bob Durst did not have a reason to have Susan call pretending to be Kathy Durst because he knew that the elevator operators had allegedly that Eddie Lopez had seen her afterwards. The problem is that, and counsel knows this, it's in their discovery, the call was made on February 1st. The original information about the elevator operator did not come from the police. It came from a spokesperson, Susan Berman, who leaked it, who gave it to the Post. The Post printed it, and that same day, they went out and they interviewed the elevator operators. So their whole theory of why, what Mr. Chesnoff said, of Mr. Durst knew he did not have to have Susan Berman call pretending to be Kathy because elevator operators had seen her.
Wait, can you just prove that? I mean,
What's that?
Can you just prove that Susan Berman was the one who arranged these witnesses?
Well, the problem is that what you would have to do is you're talking about individuals who have, she's identified as a spokesperson for the Durst organization, or for Robert Durst at the time on the statement to the Post. Circumstantially, you can come very close to proving that it was Susan Berman, as that was her role, given that we are now in a situation where we sit here, where those are witnesses and those are theories, that there was no way that we were in a position to realize it was ever to be relevant. But forgetting about that for a moment, they just said, Your Honor, this is crucial, that Bob Durst has no reason to have Susan Berman pretend to be Kathy because of the observation of the elevator operators. But again, that call is made, no one disputes it, on February 1st. He doesn't even report her missing until February 4th. He doesn't even know if she's missing. So Allegedly. And again, so the problem is that their theory of why Bob Durst would have had no reason to worry is completely impeached and inconsistent with what he has acknowledged is the history of the case and what the documents acknowledge.
But that doesn't make it inadmissible.
Your
I'm
Honor,
looking for admissibility right now.
okay, Your Honor, what you're basically saying is you are, in essence, going to allow him to put on inadmissible hearsay, but not for the truth of the matter asserted. So that in essence, he's going to get up and he's going to testify that in fact, well, I knew that elevator operators had seen Kathy, allegedly, or someone had seen her. And then court says, well, you can impeach him with the timeline. That's true. And so what I would ask the court to do, if the court wants to allow that to happen, under 352, we're going to ask the court that given the status of this case, and I want to back up a moment, as the court's aware, the stipulation, I can pull out 20 emails, was very simple. What we told them was, you have a right to present, whether it's unreliable or not, the statement of Eddie Lopez for the truth of the matter asserted pursuant to pre-arrest due process. If you present his original statement, we're going to present the statements that occurred in 2001 where he recanted everything. We're going to present the information that impeaches his credibility, his alcoholism,
Wait,
etc.
so what about impeachment of a hearsay declarant with, let's see about that.
Well,
That's
so
not a
you-
hearsay exception, is it?
Well, the court asked me if I want to use the hearsay declarant exception. At this point, I believe it's going to be 1202 by my memory.
So look, we're at 4:30. I'm not. No, I need to go. Need to go another day because you're not. The theory that he wouldn't have called Susan Berman, the premise of him not having Susan Berman make the call is that this really has nothing to do with these witnesses. It has to do with I mean, from the people's view, is that he did kill her. He denies killing her, so he's going to say, I didn't kill her. I have no reason to kill her.
Right, but he can certainly make that argument and make that statement.
Can I clarify one point?
Mr. Bailey, thank you.
So, the purported relevance is for the non-hearsay purpose of explaining why he wouldn't have asked Susan to make that call. Now, that call was made at approximately sometime, I think, between 8:30 and 9 in the morning on February 1st. These alleged sightings by these doormen were at midnight or 1 in the morning the night prior. So that means he must have learned about these sightings at some point between midnight or 1 in the morning and 8 in the morning in that 8-hour window when this call was made. Now, forget about whether that's possible or not, or even reasonable. He then doesn't report it to Detective Struck for 4 or 5 more days, and during that meeting with Detective Struck, never mentions these sightings, because he didn't know about them, that's the truth. Now, what I'm proposing is that if this is even relevant, given this timeline, these facts, it's so remote. I don't even think it's reasonable, but it's so remote that when you weigh the prejudicial effect of what's really going to be heard, it's just unfairly outweighed.
And especially for opening, Your Honor, what we're saying is, we're merely asking the court, Your Honor, at this point in time, they do not need to present this in opening. They don't. Unless and until the court finds that it's relevant. And this is a common as a court.
Well, it would be relevant. The question is whether it's more prejudicial than probative. And so look, 352 applied to a defendant testifying in his own defense seems like it's not a different test, or is it the same test?
Same test, no different. The only issue, Your Honor, remember, we're not preventing him. This is not an issue of saying what the defendant can testify to. Let's be clear. This is saying that unless and until there is foundation sufficient, and that would almost certainly come to the defendant, it should not be mentioned in opening statement, where the court literally would have to stop the defense in the middle of opening statement and say, listen, the defense has just mentioned that Mr. Durst is going to testify that elevator or operator or whatever it's going to be saw Kathy Durst. You are not allowed to consider that information to prove that, in fact, Kathy Durst was seen by the elevator operator, meaning that she was alive. You can only consider that as it goes to a state of mind. In opening statement, Your Honor, and in that situation, it is an unforced error that we would be making for no benefit when it doesn't have to be done, when the court is already, Your Honor, they are taking a brand new theory today for the first time. First time. Not in a paper, not in motion, and saying, now we want to talk about it in opening tomorrow. If for nothing else, Your Honor, than late discovery, opening statements were due. I'm going to assume that they didn't even discuss this issue in their opening that they submitted. So now what they're saying is, Your Honor, we've lost on every other potential issue. So Mr. Ray said, hey, let's throw up another one we just thought of today. How is that, Your Honor, in terms of fairness to the prosecution? How is that fair when we're now 24 hours before opening? Fine, Your Honor, delay this issue, and if the court decides that it should be Mr. Durst to be able to testify to it, then that's what happens. It doesn't need to be dealt with in opening.
Anything else, Mr. Chestnut?
Just briefly, Your Honor, how is it prejudicial if they'll have 4 months to prepare to respond to it? Secondly, when did the rule become the rule that you're barred from making an opening statement because at some point in time the other side thinks it may be excluded?
Okay, I think counsel, I think I will exclude it now. It can be, you can move to reconsider it. I'm going to exclude under 352. It's substantially more prejudicial than probative. It's not, doesn't tend to prove that fact at issue. It may be it's a defense. I'll hear you again, but it seems to me that it is more prejudicial than probative. It is, has all the earmarks of fabricated evidence that you should not profit from. It is not capable of refutation. It is here a week after the opening statements were to be presented, and when I did have an alternative theory, the people ignored that. The people did not ignore that. The defense ignored that and instead presented me with an opening statement that offered this evidence to prove the truth of the matter asserted. So that really underscores the danger here of this evidence being admitted. So with that, you can't refer to it because I'm excluding it. All right, we're going to see you tomorrow at 9 o'clock. We have more issues to discuss. Yes?
One more.
Yes?
1 minute.
Yes?
At our last hearing, the issue was discussed of remote testimony of non-principal witnesses.
Yes.
And based on the court's tentative, which was never actually put on the record, when I looked at the transcript, based on the court's tentative, it was to not allow that, and we withdrew our motion eventually.
Yes, I'm ordering it. I'm excluding any remote testimony under 1340. No one will testify video. All witnesses must testify from the witness stand.
Okay, and so if I've had a couple of witnesses inquire about doing that and providing justification, my answer to them would be?
No, I'm not allowing that.
Okay.
No, that would violate the defendant's right to confrontation under the Sixth Amendment under these circumstances.
Thank you.
Thank you, Your Honor.
Clarification, what should we remove from the opening statement that we provided?
You remove this hearsay statements regarding sightings and descriptions of Susan Berman being seen alive.
Kathy Durst, Your Honor.
Kathy Durst being seen alive. It's late. So I'm sorry about Kathy Durst being seen alive, and I mentioned so that involved police reports, and it involved drawings, all of that. That subject you cannot reasonably expect to present evidence of it.
Well, we're not precluded from speaking about Mr. Durst in the investigation that he had confidence in.
I've not excluded that.
Your Honor, there was also, we don't know, but Mr. DeGarner told me that he was planning on introducing a bunch of stuff about alleged violence by Morris Black, which the court had previously said was not coming in. I don't know if that's in his opening.
I didn't see anything like that in the opening. Okay. I mean, I just look at the pictures, I don't know what I'm gonna say.
Well, but the court's prior rulings about Morris Black stand, correct, Your Honor?
Yeah, of course.
Thank you.
And, oh wait, are we wrong?
Yeah, for the record, I said I would sign an extraction order, and I did. All right, I think a couple other things I want
Is there
to,
any further information about that, Judge? We haven't been able to contact the jail or Mr. Durst to find out whether he voluntarily didn't come or not.
well, because he wasn't in court, you should be able to visit him.
No, they won't allow visitations except on Wednesday, Thursday, and Friday. And I tried to get a private call to him today at noon. They told me that they could not do the private calls when he's scheduled to be in court, even though he's not in court.
You may speak with him tomorrow morning when he arrives. All right, anything else?
No, are we 9 tomorrow or 10 tomorrow, Your Honor?
You're at 9, Bruce at 10. Department 81 is adjourned.